In 1540, England let people will their land. Before that, land followed bloodlines, or went back to the crown. The deal was simple. Write it, sign it, 2 witnesses. A court still had to prove the paper. That process is probate. A will was never a private handoff. It was a public instruction. If you own a house, look up probate in your state. A will is a start, not the whole plan. A will does not keep your house out of court. That is the myth. A will tells a judge who should get what. Probate is the court process that proves that paper and supervises the transfer. Property that passes outside a will, like some joint titles or a living trust, is a different lane. Rules vary by state. Small estates can be simpler. Pull your deed and your will tonight. See which one actually controls the house. Die with no plan and your state writes one. That has a name, intestacy. No will means a statute, not your wishes, names who inherits. A court still opens a file. It appoints an administrator. Relatives usually take, but the order is the state's. An unmarried partner, a stepchild, or a close friend can be left out. Write down who you want handling things. Ask a local attorney how your state treats that list. Probate means a court has to prove the paper. The word comes from Latin, to test, to prove. A judge confirms the will is valid, then supervises debts, taxes, and the handoff. That commonly takes months. Fees come out of the estate. Some property never enters that file, like a beneficiary account or assets already in a trust. Rules and timelines vary by state. Search your county probate court site. Read how a regular estate is open there. This is hypothetical. Not a client, not a case file. A mom has a will. The house is in her name only. She dies. The will names her son. The court still has to prove that will, notify creditors, and clear the title. 14 months later, the house still is not sold. Rent, insurance, and upkeep kept running. A will said who. It did not move the deed. If the house is in one name, ask how title transfers in your state. Someone asked, "Does a will protect my house?" Protect is the wrong word. A will directs. It does not shield. If the house is titled in your name alone, the will is the map the court follows. Insurance protects against a lawsuit. Title and beneficiary forms decide what skips the file. Those are different tools. Screenshot your deed and your beneficiary pages. Compare them. Then watch Sunday's recap. A will is a ticket into court, not around it. 1540 made land willable. The court still had to prove the paper. No will, and the state writes the list. Probate means prove, then supervise. A house in one name still needs a title path. Different tools do different jobs. Read the one-page recap on the site, then take your papers to a local attorney.